Should I worry about prior incidents being brought up in a pending domestic violence case? Attorney Martin Kane explains that. No. Prior incidents cannot be introduced in a domestic violence trial. Generally, a past act is not going to be mentioned at trial unless the defendant testifies in his own behalf, and the defendant, now a witness, can be asked about past acts strictly to undermine his credibility. Obviously, that is not what juries are likely to do if they hear that somebody has done the same thing in the past. They are more likely to convict. The court has to do a delicate balancing act when the district attorney wants to introduce evidence of a defendant's past criminal history involving domestic violence. The court has to determine how to do that in a manner that there is not influence for jury as to anything other than the witness's credibility. In actuality, this is a legal fiction, and juries are always being influenced by a defendant's poor criminal record. But if the defendant does not testify, then his record cannot be introduced. Part of the attorney's job, if the defendant is going to testify, is to limit the amount of cross-examination about his past record as much as possible. Regardless of the above, the district attorney and the court will be fully aware of a defendant's prior criminal history, which will be an important consideration in negotiating a reasonable disposition of the case. For a free phone consultation, contact attorney Martin Kane in Kew Gardens, New York at 718-793-5700 or visit www.martinkanelaw.com.